Alex here with part 13 of the My Docket series on Corazon real estate. We have the opposition to my motion to amend complaint filed by Charles Chinnici. Again, I can't really remember. Maybe I was a little bit frustrated, but I probably felt confident that I was not going to lose, which of course was false. The district judge throws the case out, but it's okay because the Supreme Court intervenes and reverses his mistake. In any event, I think it's probably going to be a short document. It seems like a lot of the Corazon real estate CEOs paperwork isn't too long, 3 or 4 pages, and it doesn't seem to focus much on law. Still, it's worth a read, and it kind of lets you kind of see into the way that they think. In any event, I do think that this is going to be one of those videos where we just need to go ahead and take a look at what Charles Chinnici has filed. Here we have Charles Chinnici's opposition to motion to amend the complaint. He is filing, or he has a standard introductory paragraph indicating he is representing Corazon Real Estate in proper person, and then he's filing an opposition to my motion to amend. Let's see. Okay, it looks like the same arguments. He's saying that there's a motion to dismiss pending, and that the case was filed in the wrong court, and that I have fabricated a list of imaginary grievances. They're just a list of allegations, and that in fact, a lot of the allegations were admitted, and that the alleged additional damages in excess of $10,000 to justify filing in district court instead of file. Okay, so he's using the same arguments for motion to dismiss. Let's see what the next paragraph is. Deliberate and willful attempt to bury Corazon with meaningless paperwork and case law. Not really. They're pretty on point. Let's see. Rule 11b states that by presenting to the court whether, okay, so he's saying that this is a sanction rule, but he has to file it separately. There's special rules as to how to do this. So Rule 11, if he wants to use it, he has to file it in a separate document, and there's something called the safe harbor provision. So he's bringing up Rule 11, and he's bringing up the needless increase in the cost of litigation and harassment, but there's actually a certain way that you have to go about proving that. Just because somebody's using a legal system in a way that you don't like doesn't mean it's harassment. They actually have to be abusing the legal system. Using the legal system is not sanctionable. Abusing it is. He's saying that I crossed the line and am guilty of bringing the suit merely to harass them. It's still a good document to read because it shows you how they think. It shows you how they feel. I mean, he feels like he's the wronged party here. He really feels it should go into small claims court, and I get why. He only wants to pay back the people who called him out. He wants to collect the profit from the other ones who don't. I get that that's the business model. I get that that's what they do. I get that this is common practice, but it doesn't mean it's right. He feels because he's the one that got called out, it's unfair, and that since I'm the one that's not using the small claims court like all the other ones do, then what I'm doing is evil. And I understand that, but it's wrong. And it also, I hope, is eye-opening to the rest of you as to why certain industries abuse people in certain ways because they just have decided to just all do it. And it just becomes such a common thing. It just becomes standard operating procedure instead of criminal, instead of wrongful, instead of breaking the law. It's just what they all do. I'll never forget when I sued this towing company once. They went to court and the judge asked them why they did what they did, and they said, this is what we've been doing for 10 years. And in their mind, that made it okay. It was like they weren't thinking we're being evil, that we're breaking the rules. They were thinking this is just what we always do, and this is just how it always works. And from the perspective of the judge, of course, she didn't like that answer. She said, you're not going to do this anymore because it's not right. And then I ended up winning that lawsuit. In any event, this is one of the biggest things that I think will benefit people watching this series, is that you can get into the psychology of how these companies think. Is a lot of times they don't think they're doing the wrong thing at all. They think that you are harassing them for trying to stop them from doing what they and everybody else have been doing since forever. affidavit, and this is good that he has it this time. All of the facts alleged in this document are true and correct. That's what he's averring here. And then we've got a Rule 5 certificate of service indicating this document was mailed to me. And that's it. Going into the aftermath, I didn't file anything, so I incurred $0 in costs. The Charles Chinnici filed one document, but it was a free filing, so he incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. As mentioned earlier, Charles Chinnici will eventually be forced to hire an attorney, and at that point, they will review these documents to determine, what liability has been exposed, in his filings, because you can use his words against him even later on after he hires an attorney. And in the event, I doubt it would have taken them more than 15 minutes, so I imagine at the rate of $250 an hour, it's going to come to $62.50 in attorney fees for Corazon Real Estate. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.